Pardon to mention WPC number 677 of 2025. It's a matter where the petitioners have challenged the award passed by the land acquisition officer as per the 1894 Act, whereas it should have been passed under 2013 Act, and it is incomplete.
Yes, admission when little better. Appellant custody for 14 years. I've done for the hearing. My name is Appellant. Item number 16. His father-in-law Dasa Karma is today here, sir. I taken it on Monday night. There is any more there? No, madam. Base admission is there. I taken on Monday. I think it will be father. Mention is made on behalf of Mr. Prabhas Kumar, Prabhas Chandra, United States. Is this matter on 13th of January 2020. I do believe it. I don't know.
Supplementary list. Item number 1.
They have filed the affidavit. Very few. Hello.
Item 2.
Pending before the OP number. OP number? OP number 2, my lord. Representation by annexure. Annexure 6. Item 6, my lord. 6 or 5? 6. Annexure 6. Opposite party number 2. Yes. Third also same, my lord. Annexure 6. Annexure 6. Same one. Yes.
Item 4.
But this is a land acquisition case, and it is a second of litigation in this honorable court, challenging the order of rejection for payment of actual compensation towards acquisition of land, as per the assurance given by the collector, Kalahan, in the special Gram Sabha meeting held at Chhatrapur, page 50 to 60, annexure 5, my lord, and extension of RR assistance as per Odisha Resettlement and Rehabilitation Policy 2006. Earlier, this honorable court directed the OP number 4 to consider the representation filed by the petitioner within a period of 3 months from the date of production of certified copy of the order. Yes. Annexure 3, my lord, page 33, 37. Then what happened? My lord, what happened then? Then the collector Kalahandi has rejected the representation of the petitioner at annexure 4, 38 to page 38 to 41. Yes. With the contention at para 5 of the page 39 that the special land acquisition officer Kalahandi has made his submission and stated during the course of hearing that socio-economic survey holding of RPDAC meeting and development of and meeting consultation of Gram Sabha, issuance of identity cards to the project affected persons, and payment of acquisition of land and extension of benefits under RR policy have been made. The fact remains, my lord, that the collector Kalahandi in the special Gram Sabha meeting held at Chhatrapur Gram Panchayat of Lanjigarh block assured the land users to extend the compensation at the rate of 1,50,000 per acre for Bahal Kisum of land. The petitioner has lost 1 acre 48 decimals of land in course of land acquisition.
କୋଉଠୁ ପଢୁଛନ୍ତି କଣ?
My lord,
ଏଇ ପାରାଗ୍ରାଫ ଟା ତ ପଢିଲେ ତାପରେ କୁଆଡେ ପଳେଇଲେ ଆପଣ? ପାରାଗ୍ରାଫ ଟା ପଢିଲେ in page number 39
जी,
the land acquisition officer Kalahandi ତାପରେ କୁଆଡେ ପଢିଲେ ଆପଣ?
my lord, ଆମର जो special ଗ୍ରାମ ସଭା meeting ହେଇଥିଲା annex
You are
5
reading, Mr. Counsel, you are reading a part of the order. Then if you want to skip some paragraph or to go some other page, you should make a submission to that effect.
my lord,
How can we find out?
my lord, at page 39, at page 39,
41 the ordering portion mechanical class.
41.
41 ordering portion.
ordering portion में हाँ,
Based on the aforementioned finding, this court declare it concludes petitioner has duly been compensated and provided the necessary benefit in accordance with the applicable laws and policy in force. Therefore, prayer is not
made by the petitioner, variation of
Now they are disputing that they have not approved.
my lord, there was a special Grama Sabha meeting held at Chhatrapur GP as per the annexure 5 of page 52-60. And in the meeting, the collector Kalahandi has assured the land users to pay compensation.
କିଛି ନାହିଁ ତା ଦେହରେ
My lord,
କଣ କଲେକ୍ଟର ଦସ୍ତଖତ
What is
କରିଛନ୍ତି?
collector ଥିଲେ my lord.
କଲେକ୍ଟର ଥିଲେ କଣ ଆପଣ? ଆପଣ ଗାଁ
If they are agreed by the lower compensation, they have to approach the reference key other things.
now suppose this order was passed by the collector, and what is the illegality except that you say in a Grama Sabha the collector was present and he has assured something orally, except that what is there that you are to entitled to get 1,50,000 more, that is your submission.
My lord,
ସେ ମଧ୍ୟ ground ନେଇଛନ୍ତି repetition ରେ.
my lord, ସେଇଟା ଦିଆଯାଇଛି actual compensation. Actually, that less
Still you are not submitting that the calculation is arithmetically there is some mistake in it or something like
My
that.
lord, as per the assurance, my lord, the 1
If
acre
ଆପଣ
48
ସେଇ
decimal-
No, assurance must be having some benchmark basing on some
Documentary
material or documentary evidence, or as such you will speak.
No, as per the resolution passed in the Grama Sabha meeting.
Kindly find out. Where is that resolution?
My lord, page 56, annex 5.
Read it.
आठ जमी 1 लाख, माଳ जमी 1,20,000, ବନ୍ୟା ଜମି 1,35,000.
At page
Page 56, my lord.
56.
My lord.
এটা କିଏ ଦେଇଛି?
ଗାଁ ଲୋକ
এটা ଗ୍ରାମ ସଭା resolution.
ଗ୍ରାମ ସଭା resolution ଟା କାହାର? Has it been accepted?
As per
Whatever you give a figure will be
Proposal.
accepted. How can it be? It must have some basis.
They should have go with the reference to adjudicate.
Now they are not asking for reference.
Reference.
So if you are not satisfied with the quantum, you ask for a reference to the court. The LA court will decide it. Why have you come to this court?
my lord, this is already delayed and they have.
No, delay is not a ground. You have to follow the procedure of delay.
No document annexed to the petition to prove that their real the award is such amount and the award is given. The award is not also included.
and
Conclude.
moreover this resolution which you are pointing out, it is of the year 2004.
Mm.
So have you, when you filed the earlier writ petition in 2023, have you taken that ground that there is any such resolution? If that resolution was already available and that Grama Sabha was held, collector was present, and that was in 2004, obviously it was within your knowledge, then you should have said so also in the writ petition filed in 2023. You are silent, then
Safety prayer katha reference page 22 close to prayer page 36 mega class. The earlier petition, there was a prayer and a provision under section 24(2) of the right to prayer. Sorry, forest me safety prayer thara.
ନାଇଁ ଏଇ ଯୋଉଟା କହୁଛନ୍ତି ନା ଗୋଟେ ତାଙ୍କୁ କଣ କଲେକ୍ଟର ଗ୍ରାମ ସଭା
नहीं से क्लियर रेफरेंस जोड़ा डिस्पोजल पे जाइतला सेतरे प्रेयर करा पर रेफरेंस ना दे हैव टू approach the appropriate forum, not high court cannot give a direction.
there is a procedure, how you are to, if you are not satisfied, anyone is not satisfied, so
Page 36 the earlier order, petition of previously. On reputation consider.
Page 36.
Page 36.
Annexure 3 series and the same may be directed to be considered within a stipulated time.
ये representation कौन होगा?
That a representative, they are agreed.
Provisions under section 24(2) of the right to fair compensation transparency.
देखिए सेटा ये था 2013.
The old act actually.
Hmm?
Old act actually.
2013 अपना old act.
2002
24(2) of the right to fair compensation and transparency of 2013.
1894. 13.
and a notification of 2006.
Oh, so the old act would be applicable, not the new act.
Compensation assessed and paid. If not paid, we have not talked about.
But when the compensation was paid,
The compensation for the second phase of land acquisition was paid during the year 2008.
then
2008. Right.
so this new act is not applicable then. New act says that if the compensation has not been paid when this act came into force, then this should be applicable. What is that provision?
Section 24. Section 24.
In absence of permanent or permission.
If
No
there
order
is
has been made, then all the provisions relating to so and so shall apply. This act. Or and when an award has been made, then such proceedings shall continue under the provision of the Land Acquisition Act as if the said act has not been repealed. After what I see, notwithstanding anything contained in subsection 1, in case the land acquisition proceeding initiated under the Land Acquisition Act 1894, where an award under so and so has been made 5 years or more prior to the commencement of this act, but the physical possession of the land has not been taken, or the compensation has not been paid in the said proceeding, shall be deemed to have lapsed, and the appropriate government, if he chooses, shall initiate the proceeding of so and so afresh in accordance with the provision of this act. So this was that under that 2006 act.
2006 policy, my lord.
6 policy. Yes.
Revenue and Disaster Management had issued a policy on 14/5/2006.
So where is
And
that
it-
policy? Let us see that
Page
policy.
185, my lord.
185.
My lord.
And ତା ଦେହରେ provision ଥିବ ଯେ ଯଦି if anyone is dissatisfied, then what he has to do or anything like that, it is there. And what is to be provided to a person, all these things must be
What?
there.
My lord, this basically deals with the resettlement rehabilitation assistance in para 8 of this policy. That of para 8 of policy for industrial projects and under subpara 3, they have given the quantum of rehabilitation assistance to be extended to the land users. And there are two kinds of land users. One is the displaced family, and the other is project affected persons.
It is observed in the order by the collector that they have compensated. So nowhere the evidence has been adduced or advanced that how they are agreed.
My lord, they have given one-time cash assistance of rupees 50,000 during the year 2005 or 6 to the petitioner. But
No, first of all, tell us that in your case, whether it would be 2013 Act policy applicable.
no, my lord.
So,
No, my lord. We are not
then
claiming that.
which act would be applicable?
LA Act in 1984, that is the
Right.
amended act.
So whether in that act there is a provision or not that if a party after receiving the compensation amount is not satisfied with the quantum, then what he has to do, whether it has been let down or not.
Yes, under
Yes,
section 18
my lord,
reference.
my lord, also section 18.
Why have you not availed that forum?
They are quite illiterate person.
Illiterate କଣ ଆପଣଙ୍କର ଗୋଟେ provision ଅଛି ଆପଣ avail କରିବେନି please show that land.
But they have received part payment.
ଆପଣ ଗୋଟେ କଣ ଆଣିକି ଗୋଟେ ଗ୍ରାମ ସଭାରେ ହେଇଥିଲା ସେ କହିଦେଲା ଏମିତି ଏଗୁଡାକ ସବୁ କେମିତି ହବ? Reference to court, that is section 18. Any person interested who has not accepted the award may by written application to the collector require that the matter be referred so and so by the collector for the determination of the court whether his objection to the measurement of the land, the amount of compensation, the persons to whom it is payable, or the apportionment of the compensation during among the person interested. The applicant shall state the grounds on which the objection of the award is given. Provided that if any such application is made, someone is present, what is to be done. Here, this section says that if you have not accepted the award, then you can pray for a reference to the court, right?
Mine.
But in this case, you have accepted the award.
Mine accepted.
Then what is to be done? Without any objection, if you have accepted, what it presupposes?
Because they are poor people, they have accepted and they have filed representation that we should be paid compensation at a higher amount as decided in the Grama Sabha. That is their prayer. And another thing, my lord, as per this 2006 policy under para 8.3, they are required to be extended with the rehabilitation one-time cash assistance. One-time cash assistance in lieu of employment. Para 8, subpara 3, page, my lord, page 192. They are given one-time cash assistance in lieu of employment.
Please read it out.
My lord, as far as practicable, the objective shall be to provide one member from each displaced stroke other family as mentioned above with employment in the project. However, where the same cannot be provided because of reasons to be explained in writing, cash compensation as mentioned below shall be provided to the displaced other family. The displaced other family who do not opt for employment, self-employment, as mentioned in subpara A and B.
Whether this land was acquired for industrial project?
Yes, Mr. Madam.
Where from we will get it? Where from we will get it that it was acquired for industrial project? What is the notification?
Notification on 4.1 notification.
Kind.
My lord, it is page 25-28, annexure 1.
19/2006.
My lord, page 25 and 28, 29.
They got a refinery developer.
But it is industrial purpose. अच्छा कौन है ला कूटा ये जो पारा 3 टा पढ़ुथिले परा.
My lord, in the notification, my lord, at page 25, the second para, भू अर्जन संशोधित आईन 1984
सेटा लागू हो गेले हम देख चल.
my lord,
इथे कौन कूटी अछि जो वन टाइम कूट ले ते पारा 3 टा पढंतु.
para 3. My lord, as far as practical, the objective shall be provided to one member of each displaced and other family as mentioned above with employment in the project. However, where the same cannot be provided because of reason to be explained in writing, cash compensation as mentioned below shall be provided to the displaced and other families. Displaced and other families who do not get employment, who do not opt for employment, self-employment, as mentioned in subpara A and B, shall be provided by the project authority one-time cash assistance in lieu of employment at the scale indicated below. Categories of families referred to in clause 1 to 5 of para 2 F shall not be considered separately for employment in the project. However,
तो ଆପଣଙ୍କର ଏଇ ଯୋଉ ରିଟ୍ ପିଟିସନ ରେ
my
ଏ
lord,
ଗ୍ରାଉଣ୍ଡ ନେଇଛନ୍ତି ଯେ ଏଇଟା ଇଣ୍ଡଷ୍ଟ୍ରିଆଲ ପ୍ରୋଜେକ୍ଟ ପାଇଁ ନିଆ ହେଇଥିଲା
my lord,
2006 ର ପଲିସି ଅନୁଯାୟୀ ଯଦି ଏମ୍ପ୍ଲୟମେଣ୍ଟ ନ ଦିଆଗଲା ତା ପାଇଁ ଗୋଟେ ୱାନ୍ ଟାଇମ୍ କ୍ୟାଶ ଆସିଷ୍ଟାନ୍ସ ଦବା କଥା ଇନ୍
my lord,
ଲିଉ ଅଫ
my
ଏମ୍ପ୍ଲୟମେଣ୍ଟ
lord,
ଯୋଉଟା କି ପ୍ରୋଭାଇଡ ହେଇନାହିଁ
my lord,
ତେଣୁ ଆମକୁ ଦିଆଯାଉ ଏମିତି କିଛି ଗ୍ରାଉଣ୍ଡ ନେଇଛନ୍ତି writ
my
petition?
lord, my lord.
କୋଉ
Where
paragraph?
it is there? My lord, there, page 21 of the writ petition. Therefore, it is humbly prayed that this honorable court may graciously be pleased to admit this writ application, issue a writ of certiorari by casting the impugned order dated 28/4/2023, passed in this case number 31 2023 by the opposite party number 4, and issue a writ of mandamus to opposite party number 4 for payment of one-time cash compensation. As
ୱାନ୍ ଟାଇମ୍ କ୍ୟାଶ କମ୍ପେନସେସନ କେତେବେଳେ ପେମେଣ୍ଟ ହବ କେତେବେଳେ ପେମେଣ୍ଟ ହବ ଏଇ ଯୋଉ ପଢିଲେ ପରା ପାରାଗ୍ରାଫ 3 ଟା
ଆଜ୍ଞା,
କେତେବେଳେ ସମସ୍ତଙ୍କୁ ଦିଆଯିବ କି ଯାହାର ଏମ୍ପ୍ଲୟମେଣ୍ଟ
ଜଣେ member.
ପ୍ଲିଜ ରିଡ୍ ଇଟ୍ ଆଉଟ୍ again.
My lord.
As far as practicable, the objective shall be to provide one member of each displaced or other family with employment in the project. This is one.
My lord,
If the same cannot be provided because of the reason explained in writing,
my lord,
cash compensation as mentioned below shall be provided to the displaced other families, displaced and other which do not opt for so and so.
my
ହେଲା
my lord.
ତେଣୁ ଆପଣ ସେ ଟାଇପ ର ଗ୍ରାଉଣ୍ଡ ଆଗେ ନେଇଛନ୍ତି ନା ଖାଲି ପ୍ରେୟାରରେ ଲେଖି ଦେଇଛନ୍ତି ଯେମିତି ଆମ ଫ୍ୟାମିଲିର କାହାକୁ ଏମ୍ପ୍ଲୟମେଣ୍ଟ ଦିଆଯାଏନି କୌଣସି ଅପସନ ବି ଦିଆଗଲାନି ତେଣୁ ଆମେ ସେଟାକୁ ଇଏ ଯେହେତୁ ନ କରିଛୁ ସେଇଥିପାଇଁ କି ଆମକୁ କ୍ୟାଶ ଆସିଷ୍ଟାନ୍ସ ଇନ୍ ଡ୍ୟୁ ଅଫ ଏମ୍ପ୍ଲୟମେଣ୍ଟ ଦବା ଉଚିତ ଥିଲା.
My lord, I have taken also
You have
this,
to make out the
this
grounds
My
and
lord,
in the prayer portion you have to make it out.
my lord, I have taken this ground also.
So
Page 10, 11, and
Just
12.
Page
पेज 40 रे से अवार्ड ନେଇଛନ୍ତି 50,000 ହେଲେ ଅବଜରଭେସନ ଅଛି
ଏଇଟା ଅଲଗା ଟାଇପ ର ଜିନିଷ that is not the right.
ନାଇଁ ତ hence the name of Binayak
My
Dandasena such
my
as
lord,
such
page para 2 of page 14.
petitioner
page 14.
Page 14 of para 2, read application. Keeping in view of the percentage of land acquired,
Just a minute. Page 14.
my lord,
Yes.
the petitioner is eligible to get benefits of one-time cash compensation.
ପଢୁଛନ୍ତି
Para 2.
Para 2.
Eight.
keeping in view.
keeping in view of
Page 14. କୁହନ୍ତୁ.
Keeping in view of the percentage of land acquired, the petitioner is eligible to get benefits of one-time cash compensation in pursuance of R&R policy 2006, against which only 50,000 was awarded to petitioner on 31/3/2010 after lapse of 4 years of land acquisition, which is illegal in the eye of law. That the petitioner has lost land measuring an area of 69 decimal, Hata number 125/32 during the year 2006 in LA case number 9 of 2006, for which provisions laid down under the Orissa Resettlement and Rehabilitation Policy 2006 are applicable in terms of notification issued by the Revenue and DM Department under Section 4 of the LA Act. Accordingly, the petitioner is eligible to get one-time cash compensation in lieu of employment as per provision under subpara 3 of para 8 of CORAM 2006. As mentioned above, as a project affected person based on socio-economic survey report conducted by NGO CHAR engaged for the purpose. Secondly, the joint property measuring of failure.
Representation ଏ ବିଷୟରେ ଲେଖିଥିଲେ
My lord,
ଆପଣଙ୍କର representation ରେ ଯୋଉଟା dispose of ହବାକୁ direction ହେଲା
my lord.
ଏଇ ଯୋଉ କୋର୍ଟ ରୁ WPC number 8584 of 23 ରେ ଏ ବିଷୟରେ ଲେଖିଥିଲେ
My lecture is my.
ସେଟା ବି old
One-time
age
cash compensation by my lord.
impugned order ରେ page 40 ରେ ସେଟା old age
page 40
40 ରେ directly old age ये ତାଙ୍କ written ରେ ଦେଇଥିଲେ page 40
40 ରେ କଣ ଅଛି ଦେଖିବା
the petitioner here the Dandasena Binayak Dandasena
ହଁ କଣ
the land in respect to khata number such and such plot number such and such required for which amount 84,159 and rupees 67,075 was awarded on 14/12/5 and 17/10/18 by award dated 3/12/5 and acquisition of
Or
79
acquisition.
for acquisition of 79 decimal and 16 decimal land recorded in the name of Vinayak Dandasena petitioner and others of village association. Hence, the name of Vinayak Dandasena, Vidyadhar Dandasena was approved in PAP in first RPDSC held on 26/7/27, for which the petitioner was awarded cash assistance to the tune of 50,000 only on such and such in acceptance of the status of PAP. Once he has paid and accepted that award, that will be in lieu of employment. How can this again be agitated that I have not received?
My lord, the land acquisition in respect of 2004 and 5, that is being guided by the RR policy of the government, revenue and DM department, issued during the year 2003. I am giving this.
No, this
The part B of this policy, my lord,
no, just a minute.
relates to the project affected persons.
Mr. Counsel, please answer us. This notification which you are placing on annexure 1, that is 9/10/2006. So by virtue of this notification, your land was acquired.
My lord,
Honor nahi.
my lord, two phases it is acquired during 2004 and 2006.
ନାଇଁ ଏ ଯୋଉ 2006 ର ଯୋଉ ଆପଣ କହୁଛନ୍ତି land ଟା acquired ହେଲା
My lord,
ସେଟା କୋଉ land ଆପଣଙ୍କର acquired?
ଆମର 69 decimal.
69 decimal 17/10/2008 ରେ award ନେଲେ ସେଇଥିରେ observe ହେଇଛି
Just
page 40 ରେ observe କରିଛନ୍ତି collector right
just
The minimum compensation, my lord, minimum rehabilitation assistance under 2006 policy is 1 lakh. But in a 2003 policy, my lord, it is 50,000. It is specially mentioned in the Gazette notification.
ଏ ଯୋଉ 69 decimal ପାଇଁ ଯୋଉଟା ଲେଖିଛନ୍ତି ଆପଣଙ୍କର page number 40 ରେ, that was paid on 17/10/2008.
ଆଜ୍ଞା ସେଟା subsequent notification ଯୋଉ acquisition
69 days.
ଆଜ୍ଞା 69 ଟା initial notification 79 decimal
My lord, data policy notification ଅଛି ଦୁଇଟା.
No, here he is saying that the land acquisition officer Kalandi has made his submission and stated during course of hearing that socio-economic survey such and such was done in accordance with the 2006 policy. According to the petitioner, the 2006 policy has a clear mandate for payment of 1 lakh.
Yes, 2006
which was 50,000 in 2003.
2006 ଯୋଉଟା acquisition ଆଇଲା second acquisition
Ah.
ଯୋଉଟା award ହେଲା 17/10/2008
Right.
ସେଇ 17/10 ଯୋଉ ଆଟେ 69 decimal he has paid 50,000 as compensation.
No, it should be
1 lakh.
1 lakh, minimum 1 lakh. Where is that?
As per
My lord, 2006 policy will never have its retrospective effect. Because in case of land acquisition made during the year 2004, this policy 2003 policy is applicable. And as per this policy, the land acquisition has been made and compensation to the.
No, you are agreed because that even though the land was acquired as per 2006 that notification, then but the minimum you said that 1 lakh should have been paid. Where is that?
It is there in page 193 of the ORP. 193. This book, ORP policy.
13
No,
2006 रे.
No policy. Policy. 2006 policy, my lord. Page 193.
193 କୋଉଠି କହୁନାହାନ୍ତି?
ଆମର category 4 and 5. Family is coming under category 4 and 5. 1 lakh.
Just a minute.
Family is losing all
Family is
agricultural
coming
land but not homestead land.
4 and 5. 4 and 5 মানে কোডা সেটা? Family is losing displaced family is losing only homestead land.
No, but displaced and other things.
Family is losing agriculture but not homestead land. अच्छा एटा आपण को टाइप रो लैंड
My lord,
What kind of land is
what
this?
kind of land is
agricultural land, my lord.
agriculture?
And
Then-
he is a project director
So
for
that is how you say that minimum amount is should have been 1 lakh,
1 lakh, my lord.
but you have been paid 50,000.
50,000 in respect of land acquisition for the year 2004. That is,
Oh, and more
No, no. And that means you have not been paid anything for 69 decimal.
69, but nothing has. been
Nothing
paid.
has been paid.
My lord.
So this amount which you have mentioned is in respect to the earlier acquisition,
Earlier,
79 decimal.
my lord, my lord.
So that was paid in 2005.
2005, my lord.
Then what was paid to you on 2008, 17/10/2008?
And this amount, so, my lord, this amount has been paid during the 50,000 has been paid in 2008.
Ah, that is what we are saying.
And the land was acquisitioned during the year 2004. After 4 years,
Totally confusing.
my lord.
Bundle of confusion, your submission. प्रत्येक लाइन आर लाइन से कॉन्ट्राडिक्टरी
My lord,
आमे आपन को पचारुछु 2006 रो जो नोटिफिकेशन हैला
my lord.
सेही अनुसार आपनकर को जमी आपनकर एक्वायर हिच
ଆମର 69 decimal acre ହେଇଛି।
69 डेसिमल पई आपण केते टका पाइछन
କିଛି ବି ସେଇଟା କିଛି ଦେଇନାହାନ୍ତି।
वेयर इज योर ग्राउंड
ରେଟ୍ ଆପ୍ଲିକେସନ ଦେଇଛି।
the council please see your ground just made a ଆପଣଙ୍କର ଗ୍ରାଉଣ୍ଡ ରେ ଦେଖିଛନ୍ତି ଯେ ଆମକୁ 50,000 ଟଙ୍କା ଦେଇଛନ୍ତି କିନ୍ତୁ ଏଇ ଇଏଟା ଦେଇନାହାନ୍ତି ଯୋଉ वन टाइम कैश असिस्टेंस ଟା ଦେଇନାହାନ୍ତି that was your ground and you place that now you are submitting something different
No, my lord, here I am giving, my lord, sorry, my lord. I am keeping in view in this page 14 also. I have mentioned, keeping in view of the percentage of land acquired, the petitioner is eligible to get benefit of one-time cash compensation in pursuance of RR policy 2006, against which only 50,000 was awarded to the petitioner on 13/3/2010 after lapse of more than 4 years of land acquisition, which is illegal. This is relating to the earlier land acquisition, my lord, 50,000. And the clear cut, this policy is there also. Revenue and DM department policy is there.
this petition has been filed by the petitioner Vinayak Dandoshana for passing the order dated 28/4/2023 passed in this case number 31 of 2023 by Collector Kalahandi bracket opposite party number 4. And a direction to the opposite party number 4 for payment of one-time cash compensation as per his eligibility under para 8(3) of Odisha Resettlement and Rehabilitation Policy 2006, and also payment of deficit amount of compensation of land of rupees 1,14,429 along with so and so as applicable under the LA Act 1984. In pursuance of the resolution adopted in the special Gram Sabha meeting dated 6/10/2024 and so on so take later. The learning council for the petitioner placed the paragraph paragraph number 10 and 11 of the writ petition. And stated, wherein it is stated that keeping in view the percentage of land acquired, so on, so a paragraph to you would have particularly underlined the item. It is the further contention of this one, so that it is clearly mentioned in 2006 policy that if the family is coming under category 4 and 5, then minimum, then one-time cash assistance of rupees 1 lakh is to be paid. But the same has not been done in the case of the petitioner.
In lieu of apply.
In lieu of apply. But the same has not been done in case of the petition. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land counsel for the state accepts notice on behalf of opposite party number 1, 2, 4, 5, and 6. Extra copies of the writ petition be served on the land counsel for the state. So far as opposite party number 3 is concerned, requisites for issuance of notice by speed post with proof of delivery shall be filed by within a week. ये जो opposite party number 3 रो जो address टा एक type of region थी, अपन requisite file के लिए डा पहुँची होता है पकड़े, तार किसी नहीं अपन खाली लिख दीजिए managing director इटको भुवनेश्वर, address देना दी, तो Rupal Square सब तो ताकि लिखो, with proper address, matter listed code is after counter affidavit if any, but yes.
Item number 1.
Wait. Yes, next.
Item 5.
Challenging the order under Annexer 5, Annexer 4.
Annexure 4 or Annexure 5?
Annexer 5. 4 is the revision petition.
Yes.
Annexer 5. The fact of the case is like this. The subject khata number 207805 and plot number 207900 Dismill was settled in the name of one Onnama Naik.
No, you come to the operative part of that order, page number 34.
Page 30. In view of
Yes.
foregoing examination fact, I am not inclined to record the government land in the name of private individual, where suit to HAL plot number Jungle Kisam, and consequently, the present revision is liable for rejection as such division petition hereby dismissed.
Sure.
So now, I will draw your kind attention. This land was settled in the name of one Onnama Naik under Annexer 1. And the settlement that release was challenged before the additional district court, which was confirmed. And pursuant to the order passed by the Honorable High Court in OJC number, that is in OJC number 6052 of 2001, I will draw your kind attention, and Annexer 6 can have a kindly have a glance.
Yes.
The case has been reopened on 28th of January after disposal of the writ application in the Honorable High Court in Orissa in OJC number 6052 of 2000. In this OJC order of the ADM dated 2787 cancelling the lease granted by the Tahsildar Bhubaneswar in favor of Sri Onnama Naik, son of Dhani Naik, by WL case number 560 of 72 has been set aside, and the matter has been remitted back to the fresh disposal in accordance with the law by High Court order number 2 dated 16/5/2001. And here is the case, and in this order of the ADM, the ADM has inquired, running page,
So you come to the next phase. There, what are the grounds for which the additional district magistrate has cancelled? That has been mentioned.
yes,
Inquiry was not caused
yes,
properly. Proclamation inviting objection not
Yes.
properly served.
yes.
All these things are
All these-
which are required.
Laurent, ADM holds that all things has been happened, and accordingly, Laurent ADM regarding in view of page 39 of the writ application, in view of the facts indicated foregoing paras, there is sufficient reason to conclude that the lessee Sri Onam Naik under Annex 1, which I have mentioned, Onam Naik, son of Dhani Naik, was eligible to get the land on lease during 1973. Hence, lease sanctioned by the Tahsildar Bhubaneswar in plot number 2079 under Khata number 805 of Moja Andharua in an area of 1 acre of the land for lease review be dropped. The revision is dropped regarding subsequent transfer of the land by the lessee, Sri Navkishore Swai and Sri Bhaskar Bisoi. It is also established as evidence and materials on record that suit land has been transferred and has been mutated by the Tahsildar Bhubaneswar in favor of the transferee. The petition and OJC, since legality of the transfer is established and the transferee have peacefully taken over the suit land, after such the title of the transferee have been established after the mutation made by the Tahsildar. And thereafter, Annexure 7, the name of the transferee, Annex 41, page 41 of the input of the writ application, the name of the Bhaskara Bisoi has been recorded and issued the Tahsildar Bhubaneswar issued the pursuant to this order. Bhaskara Bisoi name has been recorded in the tenants column, that is 30603370, and but in the HAL settlement it has been recorded in the name of the government having no basis, for which I filed the revisions, but the Laurent Revisional Court wrongly or without application of judicial mind dismissed my revision. So when the matter was decided by the additional district court pursuant to the order passed by this honorable court in OJC under Annexure 6, there is no question to reopen dismiss. There is reopen the matter by dismissing my revision.
No, a fraudulent act cannot be.
No, there is no fraudulent act. There is no what they stated, that Jungle Kisam they have stated.
Yes.
There is no record. Where is the record?
No, where is the record? Where is the report? He is saying that no report was called for.
But in the
No, when there is no report, where is the question of knowing the status of the land?
No, status.
Where from the ADM got to know about the status of the land?
No, ADM. Then I will read proclamation. That has not been questioned.
Proclamation to hela nahi, forest department transfer नहीं क्यों जानिए? That is why the collector has reopened it.
ADM has reopened pursuant to the direction of this honorable court in OJC
No,
number 6.
after that, the order which is under challenge here right now.
Order is under challenge. That has not been reported. No inquiry has been done by the settlement of the commissioner while passing such order.
No, Annexure 6 is in your favor.
Yes. Annexure 7 is also in my favor.
Yeah, Annexure 6 and 7 in your favor.
Yes.
Because when this was remanded by virtue of the direction of this court in that WJC number 6052 of 2001,
Yes.
this Annexure 6 was passed, wherein
that was not challenged by the state or any other.
Just a minute. That lease was cancelled on these grounds. It was stated on the point of inquiry verified the WL case record bearing numbers so and so. and found that Tahsildar has, that is in page number 37. On the point of inquiry, verified WL case number so and so found that the Tahsildar Bhubaneswar has caused an inquiry to Revenue Inspector Chandaka. After satisfying himself, the Tahsildar Bhubaneswar has sanctioned the lease in favor of the lessee on 12/9/73.
38 ରେ observation ଅଛି in favor of the petition.
This is in his favor. After 38 रे कौन आसला?
As regards transform as regards सब पर है.
As regards
Finance status.
Financial
At the time of sanction of the Tahsildar Bhubaneswar has forwarded the inquiry report to conductor additional further revealed that the lessee was an agricultural laborer and not engaged in any profitable means business at the time of sanction of lease. His annual
so and so.
Then the remain WL case was upheld.
In view of the facts on the foregoing, there is sufficient reason. That is in page number 39. Seta asile in view of the facts and the foregoing, there is sufficient reason to conclude that the lessee Anam Nayak was eligible to get the land so and so. This was held after it. And the revision was dropped. And then his name was recorded. The petitioner's name was muted. RR was corrected accordingly. So then what happened?
Problem started during the current settlement. To that the record was prepared in the name of government. That's why they have moved for OSS.
No, that is what he is saying, that what is the basis of bringing the again land to the government?
Inquiry
When it was recorded in the name of the government, what my learned friend submitted, it has been recorded in the whole settlement. It has been recorded in the name of the government.
On what basis is
that's on that basis, what I like, to jungle kishon, that's the OSS case was.
ଆଗରୁ ତ କିଛି ନଥିଲା ଜଙ୍ଗଲ ପଳେଇଲା
ବହୁତ କେସ୍
ନାଇଁ ଏ କେସରେ ଇନକ୍ୱାରି ହେଲା ପରେ ଏଇ କୋର୍ଟର ଅର୍ଡର ଫଳରେ ତାପରେ ବି ସେଟା ତା ଫେଭରରେ ଯାଇଛି ଏବଂ ତାପରେ ବି ଆପଣଙ୍କର ନାଁ ଲେଖା ହେଇଛି ଏବଂ ସେ ପର୍ଯ୍ୟନ୍ତ ଠିକ ଠାକ ସବୁ ଥିଲା ଆଉ 2000
If their settlement ଯେତେବେଳେ ଭୁବନେଶ୍ୱର ଚାଲିଲା ସେତେବେଳେ ତ record ROR corrected in the name of government G department.
This order was passed in 2004 ଏଇ ଯୋଉ ରିମାଣ୍ଡ ହେଇକି ଗଲା ପରେ ନା ତାପରେ ଆପଣଙ୍କର କରେକ୍ସନ ମଧ୍ୟ ହେଇଛି ROR ଟା ହେଲା ତାପରେ ହଠାତ୍ ଏଇ ଯୋଉ ଅର୍ଡର ଟା ଆପଣ ପାସ୍ କଲେ annexure
7 ଟା କୋଉଟା?
7 ଟା ପଟ୍ଟାଟା ହେଇଯାଇଥିଲା ଆମ
ନା annexure 7 ଟା ତ 86 ର
86 ରେ ଆମର ହେଇଥିଲା ତାପରେ ସବସିକ୍ୱେଣ୍ଟଲି ହାଇକୋର୍ଟ ଫାଇକୋର୍ଟ
ନାଇଁ ଆପଣ ହଁ ତାପରେ ଯୋଉ ଅର୍ଡର ପାସ୍ ହେଲା ପରେ ଯୋଉ କୁହାଗଲା ପୁଣି ଆପଣ ନାଁରେ ହଉ ବୋଲି ସେଟା କାହିଁ
ଆଉ ଆମ ନାଁରେ ଆମେ ସେଟା କରୁ
କାହିଁକି ସେଟା ଆଉ ହେଲାନି
ସେ କରେକ୍ସନ ହେଇନି ସେଟଲମେଣ୍ଟ ରେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ନାଁ ରହିଗଲା
ସେଟା ଯେହେତୁ କରେକ୍ସନ ହେଲାନି ସେଟା କଣ୍ଟିନ୍ୟୁ ଟୁ ଇନ୍ ଦ ନେମ୍ ଅଫ
settlement current settlement recorded in the name of the government. Thereafter the OSS case filed for correction of ROR which has been negative.
All right, this writ petition has been filed by petitioner Bhaskar Chandra Puhan challenging the order dated 6/7/2024 passed by Additional Commissioner -3 Bhubaneswar in OSS case number 1721 of 2018 by annexure 5. The learned counsel for the petitioner submitted that the lease was granted in favor of, what is his name? Anam Nayak by the government on 12/9/73 and It was subsequently cancelled by the additional district magistrate Bhubaneswar on certain grounds, which was challenged before this court. And in OJC number 6052 of 2001, and this court remitted the matters back for fresh disposal in accordance with law as per order dated 16/5/2001. After the matter was remanded, the learned additional district magistrate Bhubaneswar reconsidered the matter and came to hold that there was sufficient reason to conclude that the lessee Anam Nayak was eligible to get the land on lease during the year 1973. Hence, the lease sanctioned by Tahsildar Bhubaneswar in plot number 2079 under Khata number 805 in Mauja, Andharwa of an area of acre 1.00 decimal of land for lease, and accordingly the revision was dropped. The Land Council for the petitioner submitted that in spite of such orders passed by the additional district magistrate Bhubaneswar in lease revision case number 555 of 86 on 27/2/2004, the ROR was not corrected, and in the impugned order under Annexure 5, the additional commissioner so and so, opposite party number so and so, has entertained the revision petition who has filed the revision petition before this
That is the Bhaskar,
Government.
the
That's okay.
present petition of Bhaskar Chandra.
Present petition.
Huh?
Present petition.
Present petitioner.
why you filed the revision petition, on what ground?
Division petition because I have purchased that land.
Acha, you purchased from that Anam.
Subsequent lessee to first purchase.
Okay. The petitioner, Bhaskar Chandra Puhan, purchased the land from the said Anam so and so.
No,
And
Bhaskar Vishwadhara. ଦିଟା
Second
transfer
purchase.
ତା
ମାନେ ଇଏ ଥାର୍ଡ ଲୋକ
Third look.
ଓହୋ। ମାନେ ଭାସ୍କର ସେ ଅନାମଠୁ କିଣିଲା କିଏ?
ବିଷୟୀ
ଅନାମଠୁ କିଣିଛନ୍ତି ଅନାମଠୁ କିଣିଛନ୍ତି ନବକିଶୋର ସ୍ୱାଇଁ ଆଉ ଭାସ୍କର ବିଷୟୀ
Page 18 ସାରେ ଦିଟା ଅଛି।
18ରେ
ହଁ।
ଅନାମଠୁ କିଣିଲେ ନବକିଶୋର ସ୍ୱାଇଁ ଆଉ ଭାସ୍କର ବିଷୟୀ ଦି ଜଣ କିଣିଲେ
ଭାସ୍କର ବିଷୟ ଠୁ ଇଏ କେମିତି?
Acha, the petitioner purchased the land in question from one Bhaskar Bisway who had purchased the land from Annam Naik. The petitioner filed the revision petition. Upon revision petition copy gain.
Yes, page.
ପେଜ ହଉଛି
Page 2.
Annexure 4
ଆଜ୍ଞା
before the member board of revenue Cutter camp at Bhubaneswar, which was registered as OSS case number 1722 of 2018.
and it has been transferred to the additional commissioner 3 Bhubaneswar.
Just a minute. With a prayer. For correction of the status and khata number on the strength of relevant documents and for issuance of corrected patta. The said case was transferred to
Additional
commissioner
3
additional commissioner, additional revision court number 3. Who has been pleased to hold that the Kisham of the suit hall plot number 5327 is recorded as jungle under Avada Jugya Anavadi Khata. The PWR from SO Cutter reveals that both Sabik and Hal Khata of Kisham of the suit land was Chota Jungle. Changing of Kisham of jungle land to non-forest Kisham was beyond the jurisdiction of the court under the Forest Conservation Act 1980. Accordingly, it was held that the government land cannot be recorded in the name of a private individual where the root hall plot was Jungle Kisham, and consequently the revision petition filed by the petitioner was dismissed. It is the contention of the learned counsel for the petitioner that when the basis of the order of this court, the matter was reopened, and after hearing the parties, it was found that the lease granted in favor of Annam Naik during the year 1973 lease sanctioned by the Tahsildar Bhubaneswar in favor of the lessee Annam Naik, son of so-and-so, in the year 1973, respect of plot number so-and-so 2079 under khata number so-and-so, Moja so-and-so, for an area of acres 1 decimal was proper, and accordingly the revision petition then was dropped. There was no earthly reason not to record the name of the petitioner in the Hal ROR after making necessary correction, and there was nothing on record we should be evident from the order passed by the additional district magistrate Bhubaneswar in lease revision case number 555 of 1986, that the land in question was ever recorded in Aj Chota Jungle. The Land Council submits that the order passed by the opposite party number so on 6/7/2024 is not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of the opposite parties number 1 to 4. Extra copies be served. So far as the private opposite parties 5 and 6 are concerned, requisites for issuance of notice with proof of delivery shall be filed within a week. Matter will be listed 4 weeks after. Counter affidavit filed in the meantime. Yes.
Item 6.
The petitioner before Rossi was appointed as a junior clerk typist in the Justice of Other Baleshwar Malati and Baleshwar Mala. And after she was appointed, he got promotion Mala. His scale of pay was revived by her. Your Lordship may unnecessarily kindly come to Annexure 4, the real grievance of the petitioner lies in Annexure 4 matter. But the petitioner, after the scale of pay was revived, my lord, thereafter he got the promotion, my lord. At the time of promotion, he exercised the option to be in a lower pay, my lord, till he gets the one increment in the lower scale of pay. But that was not accepted, that was not considered by the authority. As a result, he was deprived of getting one increment. Thereafter, SCB, he was eligible to get the SCB after completion of 15 years. The same year.
What you are challenging here?
Challenging, my lord,
Which order?
He is being deprived from.
No, which order is under challenge?
Which order is under challenge?
My lord, order of financial benefits.
Which order under annexure? Which one? Which order is under challenge in this respect?
If you have been deprived of, there is a forum that you should raise your grievance at what level. Then there is an appeal provision also there. You have come directly to this court. If you are deprived of a particular scale of pay,
your lordship with that observation for this project. Appeal is
डिस्ट्रिक्ट जज को आगे रिप्रेजेंटेशन देबे जे आपन को प्रॉपर स्केल ऑफ पे दिया हिनी annexing all these documents. He has to
he immediate authority खाली कर देछन तापरे आपण पळे आछन civil judge senior division district judge is there, then appeal committee is there.
Well, now he has been retired from service,
so let him he has retired from service.
Yes, madam.
Let it be given only in appeal.
The petitioner pays for so and so. On to the representation. All right. Issue notice on the question of admission, indicating therein that the
copy not sir name is
disposed of at the stage of admission. Extra copy is served on the Land Council for these opposite parties. Matter will be listed after 4 weeks. Yes.
Item 7.
Lord, item 7, I appear for the petitioners. 7 and 8 are matters, Lord, arising pursuant to the Honorable Supreme Court's order. Lord, they are now relegated to this Honorable Court. Therefore, Lord, we have filed. In fact, a similar writ petition was filed earlier, and your Lordships have been pleased to issue notice. Lord, if your Lordships turn to page 150, Please turn to page 150.
Matter Learning
There-
Council.
Yes, Lord.
185.
Item 7, Lord.
Oh, you said that the similar matter notice has been issued.
Yes, yes. That is, Lord, writ petition civil number 29765 of 2023.
Yes, yes.
It came before my Lord. And there's one more writ petition civil number 39185.
They are given that this matter will be heard on within 3 months, Lord. Lord, see para 24 of that.
Lord, please see page 150, the Supreme Court order. Page 150,
39185 of
para 69. My Lords get, Lord? May I read it?
69, yes.
It is lastly directed that any fresh dispute on account of calculation of compensation, disbursement of benefits should be adjudicated by the High Court. This court will not entertain miscellaneous application in individual cases in this regard. Now, thereafter, at page 277, the same thing, Lord, is reiterated. (277), the last para. It is further clarified that in case of any grievances by any party with respect to any order or report of the Claims Commission, the grievances should be first articulated for the High Court in appropriate proceedings. The High Court shall decide such disputes on their merits and in accordance with law and the previous judgments and orders of this court. In case the High Court is approached, it shall consider disposing of such petitions as expeditiously as possible, since the acquisition in this case occurred in 1988 and this court delivered a judgment in the year 2010. Now there is subsequently, Lord, one more order, and in fact thereafter this 39185 writ was filed in which the notice came to be issued. And now recently, Lord, in January 25, 3rd of January, there's another order where the Supreme Court reiterated the same position. Lord Debraj Monti has got the order, he'll just pass.
WPC number so and so. What order was passed there?
You will also be issued notice on
They declared the
issued notice and directed to
WPC
deposit
number
the
398 of Hartford. 39 just a minute.
Lordship pursuant to the direction of
Yes, just a minute. Should have brought that order itself. In that order was last time. The copy you have.
Should also be decided in 3 months.
Lord, in the meantime, may I just show this new Supreme Court order of January 25? 3rd January 25.
Connected matter. They may be expected tomorrow. Last order ta kaun dila? Hold on. The bar pe de sakta hai. Print bar.
January 2020.
January 20.
Filed earlier the admission order. So you filed it in the process.
3918
Reading already
completed. And this also relates to that particular village,
It is
Yes. No, these are different villages, Lord. 7 is Ratansera and 8 is Kiripsera.
These are the village Ratansira and Kiripsira. That same adopted same compensation method. So that's why.
This writ petition has been filed.
Lord, there's just one thing I want to point out to your lordships,
Yes.
which is relevant, if your lordships permit me. Please see the order of the Supreme Court now passed on 3rd January 25. Mr. Monty, just please pass on that. Please see, my lord, paragraph 24, page 18. Paragraph 24, page 18.
Yes.
Yes, yes.
May I read that?
Yes, yes.
In view of the above, it is directed that the High Court shall decide the writ petition bearing number 39185-23 as expeditiously as possible, preferably within 3 months from the date of receipt of this order. So 39185 and now these two petitions all not maybe tagged together and heard together.
This writ petition has been filed by Mahanadi Coalfield, represented Swans, General Manager, Mahalakshmi area, Swanson. Prayer was watching the reports of Honorable Claim Commission under Annexure 12, so far as it relates to village Ratan is concerned. With a further prayer for a direction to the opposite party number 1 to adopt the methodology for assessment of compensation in terms of provisions of section 26 read with possible of RR Act 2013. Stop. The Land Council for the petition has submitted that similar matter is sub judice before this court in WPC number 39185 of 2023, in which notice has been issued to the opposite parties as per order dated 7/12/2023. Land Council placed the order, a judgment passed in so and so case number dated 3/1/2025, in which paragraph number 24 it has been directed that the High Court, this court to decide WPC number so and so as expeditiously as possible, preferably within 3 months from the date of receipt of the order. The Land Council for the opposite party so far as this committee is concerned, opposite party no notice is required to be issued to the opposite party number 1. So far as opposite party number 2 is concerned, requisites for issuance of notice by speed post with proof of delivery shall be filed by next week. You file the requisites and matter be listed courts after counter affidavit if any be filed in the meantime. Please give the name for that.
Or to join the if any within a week thereafter, 2 weeks thereafter.
Yes, none. Yes, none.
So that is mentioned also.
Yes, yes, not
Atmaram NS not
But the same order in item 8 also, only the village will differ.
Item 8.
It is
8, same order, village will differ.
village with The item number 8 of Honorable. This is relates to village
Gopal.
Kiripsera.
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 All right.
Oblige grateful to your lordship.
Item 9.
Item 9 of the mention is made on behalf of Mr. S.K.Sahoo Hon'Ble for adjournment. What is next week? Yes. Place this matter in the week commencing from 13th January 2025. Yes.
Item 10. Item 10 again. Something my limited prayer before your lordship. So consider my proposal for OTA since I have already issued 15 days sale notice as well as 30 days sale notice on 12/12/2024. And on 6/12/2020 I made proposal for OTS under RBI guidelines. My
Madam, sale notice has been issued, so your remedy is not with us, but
no,
at a different forum.
People are only to direct them to consider my proposal.
That prayer also you made there, make there.
My lord,
Right? Let's come to this petition has been filed by the petitioner, so and so,
my lord, may I submit one line?
with a prayer for consideration of the proposal letter of OTS dated so and so by Annexure 3. It appears that the sale notice has already been issued. Appropriate authority.
May I submit one line, my lord?
Yeah.
My lord, since I'll approach the alternate committee within 3 to 4 days, my lord. And till date, there are no coercive action since, my lord.
The sale notice was issued on 12/12/2024, right?
My
So,
and 30 days notice, 30 days time to be
Yes.
given to me. So lordship, only till date I approached your alternate when to be granted
sorry.
stay, my lord. Since been
once
on.
the writ petition is not entertained, what is the question of giving you any relief on that? Yes. Next.
Item 11.
My lord, our name may be reflected in this.
Yes, one man
Yes, sir.
And item 11, my lord. Here, my lord, your lordship direction is there, my lord. Another annex of 4, my lord. Is it covered by my lord's or judgment orders?
Annexure 4 की change होबनी?
Nothing has to change. Same.
Annexure 3 ରହିବ ତ?
Same, my lord. Everything is
Opposite
What is
party
that
number
order?
3.
3 is also correct.
Yes, permanently in his favor. No.
Only
This
repeated.
is no. In fact, there is a change in it.
My lord, same.
Meanwhile, there is no. Meanwhile, the Supreme Court has already passed an order.
My lord, item 11.
Narottam Ratha.
That is one different context. That Narottam Ratha judgment is different. Here, my lord, for settlement of land under Auxiliary Act. And we have given representation as per Form 5.
Already.
Rule 5. Yes.
You have submitted a form.
Yes,
for
and representation we have given. My lord, similar, my lord, number of
lordship was direct to consider representation.
that is
Lordship
that
is no, I'm just saying. Lordship made the all petition same day notice, same day representation, same day, all the 15
No.
petitions.
It
It
is
create
all
doubt because whether there is no proof of submission. Only remand it is create
in the
problems.
event any such application is there.
That's there.
My lord, along
The
with
electability also be considered.
along with three
Just a
applications.
minute. ଏଇଟା ପୁରା 18/9/2024 ରେ
Yes.
ये 15ଟା ଜାଗାରେ same day.
Same day କଣ?
Same day
ଅସୁବିଧା କଣ?
notice ହେଇଛି.
ଅସୁବିଧା କଣ?
ନାଇଁ, I'm sorry. There is no proof. That is my submission.
Oh, you say that there is no acknowledgement of receipt of this. So, in the event any such application is pending.
ଦେଖନ୍ତୁ ସେଇ
Well, what I gathered information, my lord, in this case, previously, my lord, number of cases have been disposed of. I went one of the matter. They said we are not getting the file.
next case item.
Item 12.
All the similar.
Yes, sir.
As the petitioner representation for the opposite party regarding compensation, my lord.
Where is the representation?
That is annexure 2, my lord. 18, my lord.
କାହା ପାଖରେ ଅଛି?
Collector, man, Bhadrag, man.
Opposite party
2, my lord.
annexure be 2, opposite party be 2. Yes.
Item 13.
Here, as per the sale notice, I have already deposited the sale notice amount 7/5/2023 and filed the essay is pending before the DRT. Kindly have a glance to page 37. On 11/4/2023, the court reflected that we have paid the substantial amount and the bank took time for a OTS consideration. Final decision by the committee.
Who order টা place করছেন?
Page 37, 11/4/2023.
In essay.
Essay.
Huh.
Page 37. The court directed that the bank said that our committee will take a decision on the OTS. And thereafter, next page, 18/5/2023. Land and counsel for the applicant present, land and counsel for the respondent bank present, and requested time for argument. Request is considered.
matter ଏମିତି ଆସିଥିଲେ ଆଉ ଗୋଟେ ଆସିଥିଲେ ନା ଏଇ matter ଟା?
ଏଇ matter ଟା ଥିଲା Monday ରେ ଥିଲା। ତାପରେ after 1 year and some month, 39/2024, Honorable Presiding Officer is on leave and the matter is adjourned. For kindly have a glance to how many hearings.
ମୁଁ ଗୋଟେ ପଚାରୁଥିଲି ଆପଣ ଯେ presiding officer join କଲେଣି କି?
Yes. He started work from yesterday. ନାଇଁ join କଲେଣି ଯେ କିନ୍ତୁ ଆମେ page 43 ଦେଖିଲା କେତେଟା date hearing ହେଲାଣି. Now bank is taking steps.
Direction ଦେଇ ଦଉଛୁ ତ dispose of period time to ଲେଖନ୍ତୁ. This writ petition
14/1 କୁ ଅଛି for
this writ petition has been filed for a direction the ERT to finally dispose of essay number 67 of 2023, which is stated to be fixed for hearing on 14/1/2025 within a stipulated period. The Land Counsel for the petitioner placed the order sheet on 6/1/2025, from which it revealed that on 30/9/2024 was on 25/11/2024. The presiding officer was on leave, for which the case was adjourned for hearing. We wanted to know whether the land presiding officer has joined or not. Mr. Bahali, land counsel for the petitioner, submitted that the land presiding officer has joined and they has started functioning since yesterday. Since yesterday. In view of such submission, since the matter is of the year 2023, the land presiding officer shall do well to expedite the hearing and conclude this same and pass order in accordance with law within a period of 2 months. 2 months.
And no courtesy action because bank is going for sale.
Sure.
And because court is not taking, then I have deposited more civil भी 23 ମସିହାରୁ ଖରାପ ହେଇକି ରହିଛି।
ସବୁ 14 ତାରିଖ ଦିନ ପୁରା ଇଏ ଅଛି ମକର ସଂକ୍ରାନ୍ତି
ତାଙ୍କର ଖୋଲା ଅଛି DRT ଖୋଲା ସେଣ୍ଟ୍ରାଲ
ସେଦିନ ଫାଙ୍କା ଅଛି ଯାଇ କରିଦିଅନ୍ତୁ ଆଉ
କୋର୍ଟ ତ ଅର୍ଡର ପାଇଁ ରଖୁଛି କରୁନି ଅର୍ଡର ସେ ସେଲ ପାଇଁ ଗଲେଣି
ନେକ୍ସଟ
ଅଲରେଡି ଡିପୋଜିଟ କରିଦେଇଛି amount.
Yes, item 14.
This matter, my lord, petition is challenging inaction of the opposite part number 1, collector Khurda, by not disposing the petition filed before them since sitting over the matter for annexure 3 matter. Annexure 3 can be seen. Use public money is involved, more than 3 crore is dues, and every day we are following up, but no option will be passed. It will be passed only.
केबे फाइल कले सेक्शन
9/7/24
स्टार्टर सीट आणो तो मिस्टर बना this writ petition has been filed by Bank of Baroda. The prayer for a direction to the opposite party number 1, collector and district magistrate Khurda, for such and such. They are the land council for the petitioner submits that petition under section 14 of the surface IR in 2000 was filed before the opposite party number one on 14 9/7/2024. But no step has yet been taken by the opposite party number one. Let the land council for the state obtain instruction of the status of such petition put up this matter on 20th of January 2025. Yes.
Item 15.
Mr. Sahu.
On behalf of Mr. S.K.Sahoo Hon'Ble, representing the petitioner, my lordship. Lordship, I have filed this petition, my lordship, being agreed with this inaction of the opposite party number 1 and 2, wherein, my lordship, my grievance has been already registered by grievance number BPT 2024-788005 under annexure 1, page 1819, my lordship.
What was your grievance?
My grievance is, my lordship, I am the service provider to a particular hospital, my lordship, under a service agreement, my lordship. Somehow, my lordship, a CIRP process was initiated, my lordship, and during the process, now when the process is going on, my lordship, my service agreement was illegally terminated by the opposite party number 3, and the opposite party number 3, by violating
opposite party number 3.
Yes, my lordship.
Yes.
And the opposite party number 3, by violating the terms of the lease deed, my lordship, and without taking permission from the lessor.
Party number 3 is a private individual.
No, my lordship. Opposite party number 3 is the resolution professional appointed by the NCLT, my lordship. The Siva Kumar Mahapatra, my lordship.
Who is he, Siva Kumar?
He is the resolution professional appointed by the NCLT, my lordship. Who is the resolution professional of the Medirat Tech Limited, my lordship, which is the opposite party number 5, my lordship.
So who is Medirat Tech India?
Medirat Tech Limited is the lessor, my lordship.
So no.
Lessee, my lordship.
What is their entity?
My lordship, Medirat Tech Limited had taken the lease of land from the government to set up a cancer research institute, my lordship. As because there is no cancer research institute in the state, my lordship.
No, but that's a private organization.
So it's a private organization.
Yes, my lordship.
So how it will be maintained?
No, my lordship, it is maintainable as because, my lordship, my grievance is against the state of Orissa, my lordship. My grievance is already registered under annexation. My
lordship, is against a private individual. He has given you the lease and he has
no, he has not given me the lease, my lordship.
For the NCLT Act, when the NCLT proceeding initiated, the entire management is taken over the registration process.
Yes, my lordship.
So
that is the order of NCLT. Where is that?
That order is annexed under, my lordship.
Annexure 5.
Annexure 5, my lordship.
But the alternative remedies there, each cannot be entertained.
No, my lordship.
No, but in any case, the contract is between that firm and the organization.
My lordship, I am not concerned. I am not asking for any stay in this IBC proceeding or against the proceedings which are going in the NCLT or NCLT. My humble submission is that, my lordship, my grievance has already been registered by the government authorities, my lordship, since September 2024. It has not been disposed of as yet. My only request to the government authorities is, since you had given the lease.
No, that is there, provided this REIT is maintainable. We can give it a REIT.
My lordship, the REIT is maintainable, my lordship.
There is no order. Because the management taken over by the registration profession in order to avoid any manipulation but other things. He has cancelled that agreement. He may approach, the petition may approach the private entity and there. Here is another aspect, man. Here is the Hemalata Hospital represented through engineer Subhasri, daughter of Aravind Ratha. The father is OP4 here. The doctrine of interest is also involved. Let him approach to the authority concerned NCL.
My lordship, may kindly see the page 18 and 19. My lordship, for a brief moment, my lordship, may kindly see this page 18, my lordship. Why I am not seeking any relief against this.
No, whatever relief may be sought for is not important.
But my
provided
grievance
it
which is pending against the government authorities might be disposed of, my lordship, when it is registered since
Government cannot
2000
entertain.
September 18 to September 2024.
Who is that authority in the government?
My opposite party number, my lordship. Opposite party number, the director of estates, my lordship.
No.
Opposite party number
You say that
2, my lordship.
the agreement was with this opposite party number 5. Medira Technical India Limited, represented by director.
My lord, the
Private
unit's
entity.
name is, my lordship, Hemalata Hospitals Limited also, my lordship. The unit name is also there. And my lordship, already my humble submission is my grievance has been registered. And my lordship, another further thing, my lordship, the government is saying this, my lordship, and government has itself issued a letter to that said individual Shiva Prasad Mahapatra
And
that you did not inform us regarding the CIRP proceeding. Hemalata Hospital Limited informed us. That also I have annexed under 160
director
and
estate is only
160.
ex officio member.
Yes, my lord. My lord, he has himself issued a letter to the Shiva Prasad Mahapatra to implead him as a party.
All right, this petition has been filed. Seeking
My
for
details may be disclosed
direction
upon.
to the opposite party, namely Shiva Kumar Mahapatra, to show cause regarding the illegal termination of service agreement executed between the petitioner and opposite party number 5, Medira Technical India Limited. Since this dispute between the private individuals, this rate is not maintainable and accordingly disposed of this.
My lordship, my lordship, may kindly just one
Yes, next,
submission, my
next,
lordship.
next.
Item 17.
My lordship, my lordship, may kindly adjourn this matter. My senior
Sorry.
will argue this matter, my lordship.
Yes,
Then what did you find?
item 17.
May I please, your lordship? Father, the case of the petition is the case of the petition is petitioner being the employee under opposite party number 2. He has being an employee, he put his signature Nuria in different papers, and thereafter the opposite party number 2 get the loans from the bank. Your lordship may kindly come to page 25, annexure 1. The order passed by the Lord DRT.
What is your prayer here?
My prayer I'm challenging the order of the DRT and DRT to issue
No.
writ of certiorari. Your lordship may kindly come to page
No,
22.
what order was passed by the DRT?
Your lordship, annexure 1, my lord.
You availed the loan or what?
I am the guarantor. I am the
You are
so-called
the
guarantor.
guarantor.
Miller.
The
Without
loan was
knowledge-
availed from the Punjab National Bank.
Yes, sir. Opposite party number 2 availed the loan from Punjab National Bank.
Okay, you are the guarantor.
Miller.
Then what happened? The surface proceeding was initiated.
Miller.
Then what happened?
Essay application was presented just after the
No, what order was passed by the DRT?
DRT. Your lordship may kindly come to page 27.
27.
Miller. Consider
26, 27. Order
Consider-
dated 22nd March 24.
Miller.
Hmm.
Considering the aforesaid facts and circumstances and the considered opinion that there is no sufficient cause for condoning the delay.
Yeah.
Accordingly, the IA number so and so filed for condonation of delay is dismissed.
Hmm.
Hence, the NDN number filed by the applicant is also dismissed. Taken? Your lordship may kindly see the
Then what happened? Then this order you challenge in the DRT.
DRT
What is that?
by filing in email portal.
कौन हैला? Order कौन हैला?
They did not entertain. Your lordship may kindly come to page 30, annexure 3.
Yes, 30 years.
An appeal under section 18 is received by post in matter of Prashant Kumar Sahu versus Punjab National Bank.
कौन तो रही है कहीं?
Punjab National Bank and others in Indian number so and so along with a payment of received so and 130 received from you is hereby returned with a request to file the appeal. Also delay application, waiver application, etc. And Your Lordship,
We filed for second time.
And
This,
send the hard copy of this along
We
with the next
filed
time.
58 is the relevant question.
you know, thereafter I have also filed the second application before the DRAT. Your Lordship may kindly come to
58.
Miller, 58. All the
58 and 59. 58 and 59.
58 and 59, Miller.
ପଢନ୍ତୁ 58 ଟା
None appears for the appellant and respondent. Both the case was filed through online on 4/7/2024 and hard copy on dated so and so. After scrutiny, the matter was listed before the registry bench on 12/7/2024 for removal of defects. Order dated 10/7/2024, but none appears from that. Then the matter was listed again on 25/7/24 and also today for removal of defects, but none appears and hence defects have also not been rectified till date.
On 6th.
So Lordship may kindly come to Annexure 9, 59, return of documents. Documents received on dated 6/8/2024.
We have sent
The notice, the entire document has been sent to DRAT, Lordship.
after rectification.
The defects as raised by the DRAT has already been rectified by the present.
8 ତାରିଖରେ ଆପଣଙ୍କ କାମ ସରିଯାଇଛି ଆଉ 14 ତାରିଖରେ ଦେଲେ କଣ ହବ?
Miller, prior to that,
Not prior to that. ଆପଣ ନିଜେ ପଢୁଛନ୍ତି order number 4 dated 8/8/24 ରେ ଆପଣଙ୍କର since defect was not rectified, this matter is declined to be registered due to so and so. ତ ସରିଗଲା ବନ୍ଦ ହେଇଗଲା ତାପରେ ଆପଣ 14 ତାରିଖ ଦିନ ନା 15 ତାରିଖ
Lordship may kindly come to Annexure 9, 59.
ତାଙ୍କ ପାଖକୁ ପୁଣି ପଠେଇଦେଲେ
ପଠେଇଦେଲେ
ରିଟର୍ନ କରିଦେଲେ 6 ତାରିଖ
Thereafter again that has been sent on 6/8/2024.
6/8/20.
On dated 6/8/2024, 59, page 59, Annexure 19, Annexure 9, Miller.
Annexure 9
Lordship.
14 ତାରିଖ ସେଟା 14 ରିଟର୍ନ ଅଫ ଡକ୍ୟୁମେଣ୍ଟ ସେଟା କି ରିଟର୍ନ କଲା ରେଜିଷ୍ଟର
Register return कर.
ହଁ ଆପଣ ରିଟର୍ନ କରିଦେଲେ ଆପଣ ଡକ୍ୟୁମେଣ୍ଟ
Miller.
ଡିଫେକ୍ଟ ଟା ନୁହେଁ ଯେ ଏଇ ଡକ୍ୟୁମେଣ୍ଟ ଗୁଡା ଆପଣ ଫେରେଇ ଦେଲେ ମାନେ ଡକ୍ୟୁମେଣ୍ଟ ଗୁଡା ତାଙ୍କ ପାଖରେ ଥିଲା ଅନ୍ୟ କଣ ଡିଫେକ୍ଟ ଥିବ
All the defects raised, your Lordship may kindly come to page 55, Annexure 8. All the defects raised by the registry of DRAT have already been complied, except the number 1, that is rupees 6,125.
ସେଟା କିଏ ଦବ?
That is not applicable to the present petitioner. Your Lordship may kindly
That you should have moved before the authority.
no, Miller, that is not applicable at all. As per the securitization interest,
ସେଟା
security interest enforcement rule.
ଆପଣ ଯିବେନି ଘରେ ବସିବେ କୋର୍ଟ କେସ୍ ପଡିବ ଡକରା ହବ କେହି ରହିବେନି ଡିଫେକ୍ଟ ରିମୁଭାଲ ହେଲା କେହି ରହିଲେନି 3 ଥର ଆପଣଙ୍କୁ ସମୟ ଦିଆଗଲା ଆପଣ ଡିଫେକ୍ଟ ରିମୁଭାଲ କଲେନି
We have removed defect on 6th.
Miller may kindly come to the security interest enforcement rule. Rule 13A. Rule 13.
ଆପଣଙ୍କୁ ଯଦି ଏଇଗୁଡାକ ଡିଫେକ୍ଟ ଦେଖେଇଲେ ଏବଂ according to you that this deficit copy ଯୋଉଟା ଆପଣ ସେ ଦେଖେଇଛନ୍ତି to be paid that was not proper, you are not to pay that deficit copy, then you should have filed an application that this particular defect which has been shown.
My lord, from Kotak to Calcutta is 500 kilometers. In the meantime, I have complied all the defects.
No, that
as
you
raised.
say. That you say. How can you know?
Miller,
There are several defects. How can you know that you have removed all the defects?
all the
Except
defects,
that
I have taken the ground that all the
that ground is before this in the read.
Yes, Miller.
No.
All the defects I have already complied with.
Where is the order of that authority that barring the defect number 1, rest of the defects have been removed?
No, they have not given any authority. They have simply dismissed on the ground that they were not compliant.
Yes.
But we have complied
How
all the
can you
defects.
say?
And the order defect number 1 is not
Where is the order to that effect?
not applicable to the present.
No. When 3 dates have been fixed and in none of the dates you are present before the authority,
Not filed any document.
how can you accept?
kindly come to 13B of
That is
ଆପଣ ସିଆଡେ ଆପଣ ଯାଆନ୍ତୁନି ଆପଣଙ୍କର ଏଇ ଯୋଉ ଡିଫେକ୍ଟ ଟା ଦେଖା ହେଲା ए डिफेक्ट टा देखाला आपण देखंतु 10/7 रे देखैछन हला ता तळे डेट मध्ये पडछि रजिस्ट्रार को सिग्नेचर तळे पडछि प्लीज लिसन टू अस कम टू दैट डिफेक्ट जोटा अनेक्सर 8 रे डेट पडछि तळे डेट केते पडछि 10/7
12/7/2024
10/7 10/7 रे 12टा डिफेक्ट आपण केस रे अछि बेली रजिस्ट्रार इंडिकेट कले ता परठू तीनटा डेट पडिला 12/7/2024 तापरे 25/7/2024 तापरे आ गोटे पडला 8/8/2024
on 6 I have already
Where is that?
removed.
Where is
Your
that?
page 59.
50?
59 Milord. Page 59. Documents received on 12/8/2024 by post. Your letter dated 6/8/2024. I have sent in to 6/8/2024. They have received on 12. They have received on 12 and caption subject are returned here with as the case has already been declared
Yes,
to register.
by then it was on 8/8. That is what Marlet is saying. You have sent it after 8/8.
They on the ground of defect. I cannot refuse my case because I have a meritorious case. On that ground, I
So
cannot
you,
throw down.
if you remain here and you just communicate over phone,
No.
how can it be done?
My lord, on e-filing portal, I have requested the honorable court that that application may kindly be accepted. As because
No. Had you submitted these applications before 8/8, and that could have been some ground right now.
6/8 I have sent, my lord. 6/8 I have sent.
No, you have sent in ordinary post. They have received it as
On
well.
speedy post, my lord. All the applications sent
Might be that.
directly on the speed post. We'll file the receipt. We file the receipt, your lordship. May kindly adjourn to some other day. We'll file the receipt, your lordship.
Who is appearing? You are appearing for Punjab National Bank.
Yes. I have instructions to file my application. Apart from that, the property has already been sold and registered. Possession has been handed over since long, my lord.
Milord, on 21/11/2023, they have taken the possession. Milord, on 21/11/2023, they have taken possession. On 23, I have presented the securitization application before the law DRT cut off. Within the limitation. Because it's a continuous cause of action, Milord. There is no limitation. But the law DRT wrongly, without application of mine.
दोनों से बहुत application करछन्ती तीनटा डेट application
No,
कले माइंड केते दरकार
I am arguing on DRT, not DRT, Lord. DRT, Milord. DRT cut off. Without application of mine, my application which I have presented on CA has got no irregularity on limitation. Milord.
what you want to file, you say that you are to substantiate that the defects were removed within time.
That letter.
On
Exhibit 9 on
6/8/2024, I have already sent the documents from SPD post. 6/8/2024, page 59, annex 1. And acknowledged by the DRT.
6/8/24 आपण जदि गोटे डॉक्यूमेंट पठेले सेटा केबे पहुंचीबो केबे पहुंचीबो एक्सपेक्ट करू
on speedy post 24 hours 28 hours
डेट अछि 8 तारिख दिन 8 तारिख
28 hours
डेटा डेट जाई फाइनल डेट रहउची 8 तारिख दिन
the person after his property has been sold by the illegally by the bank, he is now in food. His sole homestead property has been sold, my son. By misrepresentation, the employer has taken his property as security.
Yeah.
The petitioner herein is homeless now. His employer.
This matter should have been reviewed by this that you
Before the DRT, the land DRT did not entertain any of this.
No,
On the ground of
13.2
limitation, he has
13.2 was there, 13.4 was there.
we have
13.2
submitted everything on SA. Why after 13.4 we did not approach the
petitioner has filed this writ petition challenging the order of the DRT Cuttack in SA number
ऐसे डायरी
ऐसे diary number purchase DY is one so এটা annexure 1 আছে and annexure 1 dated হচ্ছে 22/3/2024 so also the
डायरी नंबर 1084 by 2023
1084 of 2023 annexure 1 the location so also the order passed by the DRAT dated সেটা কেতে হলো
14
page কেতে
page 58/8/2024 58
DRAT on dated 8/8/2024 it appears that the land DRT
sorry for interruption my lord not
dismissed the interim application IN number 1084 of 2023 which was filed for condonation of delay. And accordingly, the NDN number 1084 of 2023 filed by the petitioner was also dismissed, which was filed challenging the proceeding under section 14(1) of the Surface Act initiated before the District Magistrate Cuttack, challenging the aforesaid order dated 22/3/2024 passed by the Lenin DRT Cuttack. The petitioner approached the DRAT Kolkata in a regular appeal DY number 621 of 2024. And from the order dated 10/7/2024, it appears that 12 defects were shown by the registrar, and the matter was posted to 12/7/2024 for appearance and removal of defects. The case was taken up on 12/7/2024. On that day, neither the appellant nor the respondent appeared, for which the case was posted to 25/7/2024 for appearance and removal of defect. The matter was next posted, taken up on 25/7/2024. On that day also, neither the appellant nor the respondent appeared. And
respondent appeared notice has not
not and the matter was posted to 8/8/2024 for appearance and removal of defect. And when 8/8/2024 the matter was taken, neither the appellant nor the respondent appeared, and the registrar observed that the case was filed through online on 4/7/2024 and hard copy was filed on 10/7/2024, and after scrutiny of the matter it was listed before the registry reached on 12/7/2024 for removal of defects by the order dated 10/7/2024, and since none appeared, the matter was listed on 25/7/2024 and again on 8/2024, and since nobody appears and defects were not rectified, the matter was declined to be registered due to non-removal of the defects by the appellant. Accordingly, on 14th August 2024, all the documents which were filed by the petitioner was returned. The Land Council for the petitioner submitted that the petitioner had sent the documents on 6/8/2024, and the letter dated 14/8/2024 shows that those documents were received on 12/8/2024, and therefore the order of dated 8/8/2024 should not have is not sustainable in the eye of law, and that the petitioner should be provided an opportunity after removal of the defects, argue the matter on merit. What is the opportunity? Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Mr. Please give the name, so appears for opposite party number 1. What is opposite party number? Copy of the transfer the Charban from opposite party number extra copy the declares for issuance of notice be filed within a week. Matter will be listed after 2 weeks, and counter activity can be filed in that time. Yes.
Item number 18.
Challenging the order under Annex 8, the notice of eviction under OPL Act has been issued to the petitioner. The petitioner is a homesteadless person who is residing since the year 1970.
What you are challenging here?
The notice under Annex 8 matter, OPL Act notice is that.
So why have you come here?
There is a provision of appeal matter. The liberty, no, not my respective prayer is that.
आपण एठी आसीबे काई अपील न फाइल करी पुनी आमे ऑब्जर्व करिवु आपण फाइल करंतु लेखन
Since today they have not given me the certified copy till date.
All right.
petition has been filed challenging sworn Iran counsel for the petitioner submits that since against the input notice under section so and so appeal lies, he will be permitted to withdraw this writ petition to approach the appellate authority. Accordingly, the writ petition is disposed of.
Till the filing of the
No. Question of filing of file tomorrow.
Kindly instruct to provide me the certified copy. I have applied this.
You apply. You do not know whether you are applied or not.
I am giving the copy.
No, for that a read will be there. A direction in the read will be there. Certified copy, you can get it.
Yes.
Item 19.
Please, Lordship. In this matter, Your Lordship, the petitioner prays to settle the account of the petitioner as the objection given by the petitioner to the demand notice has not been accepted by the bank election.
Possession notice has already been issued.
Yes, Lordship, only the possession notice has been issued.
Alternative remedy available disposed of next.
Item 20.
Item 20 is a covered matter. Possibly repeat copy of the order.
You provide a copy to the London State Council so that you can verify. Mr. Nayak,
28.
just it is a application where this order was passed. Have you given a copy?
No, sir.
Read that one the got a page order. Just go to them. To dispose of that 28 application, same order passed. Yes, annex 2, same order. Yes.
Item 21.
Application. Is by challenging the order of under Annex 5 of the petition. The order of the learned district judge.
With the Lordship permission, I am appearing for the opposite part number 5. Let a copy short manner. I find my local number.
Copy 5.
Man.
There are a number of opposite parties.
Man.
So let us see, let us know what is the matter. Yes, sir.
Yes, sir. Hello, here what has happened? Lordship, the OP number 5 has filed a suit for partition. After the notification of land acquisition has been issued, the suit has been filed by the OP number 5, who is the legal heir, claiming to be the legal heir of a recorded tenant. Let's see what has happened.
I filed a suit manner that was decreed, preliminary decree and
Suit for partition was filed, which was
Filed.
decreed.
decreed man.
Then
And
appeal
share
was
of the share of, and in the meantime, that land was acquired by the.
No appeal was prepared.
No appeal was preferred.
Right.
My lord, that the London district judge has divided all the shares according to the decree.
Right.
And
Challenging that order of that London district judge, we have come before this honorable court in this writ petition.
That is what he said. In writ petition.
My lords. My lords, because what has
That
happened.
was suit for partition.
Yes, your lordship.
Why and writ?
Lordship, because the land was acquired by the National Highways Authority under National Highways Act, and the land acquisition officer has preferred the LA case before the London district judge.
All right.
For the apportionment of the compensation.
That is different proceeding.
yes,
Yes, your lordship.
That is a different proceeding.
For
So
that,
you are coming against the civil
LA
suit or that?
No, my lords, against the LA case.
LA case.
Lordship, before this honorable court.
No, unless you see the both have linked to each other.
Lordship.
So unless the order, the decree which has been passed in that partition suit, that is set aside, he has just to act upon the decision of the civil court.
My lords,
He has just divided.
I will just clarify lordship on that regard. My lords, that suit has been decreed ex parte on against my lords. One second.
ex parte judgment টা যদি সেই টাইপ ର ରହିଲା ଯଦି ତାକୁ ସେଟା ଗୋଟେ judgment ନା ନାହିଁ ସେଟା
My lords, my lords.
ତାହେଲେ ଆପଣ ଯଦି ex parte ହେଇଗଲା ଆପଣଙ୍କର grievance ଥିଲା ଯେ ex parte judgment ଟା ଆପଣ duly notice ହେଇନି ବା ଅନ୍ୟାୟ, so you have to take recourse in accordance with law.
What has happened, I will just let you know. Actually, lordship, the petitioner is the successor of the decree.
No, don't come to the merits. Why are you coming to the merits? A very technical question is before you. If the partition suit is made with ex parte, if it has reached finality, you have not challenged it, the authority has acted according to that.
My lords.
Yes. What is that?
with your lordship permission in the district judge also, the reference court, my lord. They have not raised that
Yes.
issue,
My lords, so
that it is
If
a
your
ex parte
lordship-
judgment.
if your lordship will see the my lords once that was the mutation case preferred by that OP number 5. That is on annexure 4. If your lordship will see that the page
Partition
When-
suit ରେ ଯାହାର ଯାହା share ପଡିଲା
My
ସେ
lord.
ଅନୁଯାୟୀ compensation ଟା distribute କରିଦେଲେ।
my lords.
ତ ଯଦି ଆପଣଙ୍କର grievance ରହିଲା ସେ suit ର ଯୋଉଟା ହେଇଛି ସେଟା ex parte ହେଇଛି, ତେଣୁ share ଟା ଠିକ ଭାବରେ distribution ହେଇନି, ତେଣୁ ଆପଣ ସେ suit ର order ଟାକୁ ଯଦି challenge ନ କରିବେ ତାହେଲେ ଏଇ result ହିଁ ଆସିବ, ଆଉ କିଛି ଅଲଗା ଉପାୟ ନାହିଁ।
My lords, if your lordship will allow, I will just state the facts only.
No, you are not, you are still harping, then
No, lordship, I'm not.
we are putting a questions to you that why you have not challenged the order which are or the decree which has been passed in the civil suit.
Because my lords, there was the ex parte decree. After that,
You
my
are
lord-
not able to understand.
no, my lords.
If that was so, as Mr. Amitabh is also saying, Mr. Tripathi, have you challenged it before the district judge?
No, your lordship.
And so, what is the question? So the district judge, as a LA authority, has simply acted upon it.
Yes, sir.
That's all.
That is the
That is it.
Because my lords, we came to know about the decree when that was noticed.
Again,
Then you are going
so
back.
that means you are challenging the ex parte decree. You challenge it before proper forum. You are free to do it.
My lords, take a liberty to maybe post, maybe there may be.
This we are disposing of, you withdraw it and take appropriate steps in challenging that. What is that civil suit number have you given you?
Yes, lordship.
Why, which
39,
paragraph?
2013.
Huh?
Civil suit number is 239.
PS 239 of 13.
Lordship.
Connection. Yes, sir. The writ petition has been filed by petitioner Ramachandra Munipal, challenging the judgment dated 8/10/2024 passed by the London District Judge Hon'Ble under section 3H4 of the National Highways Act in LA case number 12 of 2020. The Land Council for the petitioner has filed the judgment passed by the London Senior Civil Judge Talche in civil suit number 239 of 2013, in which the prayer was made for passing a preliminary decree for partition, dividing the suit property in mids and bounds. The decree was passed, and in terms of the decree, it appears that the impugned judgment was passed, disbursing the compensation amount. The contention of the land council for the petitioner is that the petitioner was set ex parte in the aforesaid civil suit illegally, and that is the reason why the impugned judgment passed by the London District Judge on board in LA Case number 12 of 2020 under Annexure 5 is not sustainable. We are not inclined to accept the submission made by the Land Council for the petitioner, in as much as since the impugned judgment is based on the judgment passed by the London Senior Civil Judge Star Chair in civil suit number 239 of 2013, and if the petitioner has any grievance against the said judgment passed in the civil suit, appropriate remedy is available to him, and he is at liberty to approach to avail such remedy. Accordingly, the writ petition is disposed of. Yes.
My name may be.
So Amitabh Rai, Land Council for the opposite party number 5 is
We are for
present.
the OP number 4.
Mr. Padhi along with Swanso is present for the
Solution
opposite party number 4. Yes.
Awesome.
Item number 22.
Here, my lord.
Here, sir. My God, the petition already surrendered. When the report may be called.
So why you not producing the surrender certificate? So your information is that he has already surrendered. The Land Council for the appellant submits that he has received instruction that after availing the interim bail as per order dated 23/7/2024 passed in IN number 466 of 2019. The appellant has
done with surrender report on 25/4.
No. What you dates are there? Has already surrendered. But since the Land Council for the appellant is not filing the surrender certificate, let a report be called for from the Land and Trial Court. Whether the submission made by the Land Council for the appellant is correct or not. Put up this matter on 20th of January 2025. Yes.
Number 24.
Maybe. In the case where the parent appellant is in custody for more than 10 years and Malad cannot to direct the state to get the custody certificate. On two of grounds that I want to challenge. First, actually a custody certificate has achieved.
What's the
Sorry, master. Thanks, master. On two grounds, Malad. First, the Land Court, Malad, who has tried the case, he doesn't have the jurisdiction to try the case, Malad. Because it's a schedule offense, it requires to be tried by court of the schedule matter, which is meant for the particular purpose. And it's because the additional sessions of Malad Barampur is not a designated court under the schedule offense, Malad. He has no jurisdiction. That is the first and foremost submission to my lord. And the other aspect is that absolutely no evidence. 7 except one revolver was allegedly seized, and it was also not.
How many cases were instituted against?
My lord, to my instruction around 135. Now he has been acquitted in around 90 case. So the remaining 35 was there.
Criminal antecedent and children. Case samudaya.
And 7 except this, in all other cases, is acquitted. I guess. Let's say 7 except this, all other cases is acquitted. And out of 35, now in 6 or 7 cases is on bail, and around 13 cases are at this stage.
Have you filed any comprehensive affidavit relating to the status of those cases? 135. 135 case, John Gonare.
This is the case where he was arrested and subsequently all the cases taken into him.
Report is saying that 27 is the 27 cases is pending against me.
You put in 135
Let's say out of the remaining codes.
Remaining but
ମାନେ ପିସ୍ ମିଲ୍ କରି ଆଣିବେ 27ଟା କାଲି ସକାଳ 5ଟା ରହିଲା ଏଣ୍ଟାୟାରଲି କ'ଣ ଆପଣଙ୍କର ଇନଷ୍ଟ୍ରକ୍ସନ ଆସିପାରୁନି ଯେ ଗୋଟେ ଲୋକ ନାଁରେ ଯାହା ନାଁରେ 135ଟା କେସ୍ ଅଛି ତାକୁ ଆପଣ କେମିତି ଆଣି ରିପୋର୍ଟ ଦଉଛନ୍ତି ଡିଟେଲ ଆଣନ୍ତୁ ଟୋଟାଲ କେତେଟା କେସ୍ ଇନଷ୍ଟିଚ୍ୟୁଟ ହେଇଛି କେତେଟା କେସ୍ ରେ ସେ ଖଲାସ ହେଇଛି ଆଉ କେତେଟା କେସ୍ ରେ କନଭିକ୍ସନ ହେଇଛି ବର୍ତ୍ତମାନ ସେ କେସ୍ ର ଷ୍ଟାଟସ କ'ଣ ହେଲା
ବେଲ୍ କେତେଟାରେ ହେଇଛି
the Land and Council for the state has ଦେଲେ ନା ନାହିଁ custody certificate produce the custody certificate which is taken on record. Land and Council for the appellant submits that he has instruction that there are 135 criminal antecedents against the petitioner Sabyasachi Panda. However, the Land and Council for the state submits that since he has received instruction only in respect of 27 cases, he may be given some further time to obtain instruction in respect of the other cases and their status. Put up this matter in the week commencing from 27th January 2025. Yes.
May further to because my lord may also direct the state to take instruction regarding the applicability of my contention that the particular the trial court doesn't have the jurisdiction, and this Bikramjit Singh versus state of Punjab, the Punjab, his husband, where I will give a copy. Let him also examine to that aspect.
The Learning Council for the state, a petition was submitted that the Learning First Additional Session Judge Barampur tried the ST case number 33 of 2015 under section so and so has no jurisdiction to try the offence, and he has relied on the decision of the Honorable Supreme Court in case of
Bikramjit Singh versus state of Punjab,
reported in
criminal appeal number 6667 of 2020.
Unreported.
unreported in
No, reported I'm sorry.
party nada
Again, Bikramjit Singh versus state of Punjab, criminal appeal number 667 of 2020.
ये कर देवे सर्च कर देवे अनुपात रे बाकी और पार्टी ना भी देखि देवे और क्रिमिनल अपील नंबर ता देखि देवे समाधान गोटे ना रे विक्रमजीत सिंह ना दुनिया केस ये लोग click कर दे
Not judicial, try the schedule offenses because it's coming under schedule offenses.
all right next
number 25.
After availing the interim bail period, which was passed on IN number 1972 of 2024, dated 11/9/2024. The appellants are surrendered and the surrender certificate also attached. Not that. Another IA has filed for the bail, that is 15 for 25.
right I 20th of January 2025
ଅପେକ୍ଷା କରିଛି ମୋ ଯଶୋଦା ମା ଓଠରେ ରହିଛି ତା ପୁଅର ନାଁ ସ୍ନେହ ଯେ ତାର ଶସ୍ୟ ଶ୍ୟାମଳା ଆଉ ରାଗଟି ଯେପରି ମେଘକୃଷ୍ଣ କଳା ଅପେକ୍ଷାର ରାଗ ମଧୁର ବର୍ଷାଏ ସୂକ୍ଷ୍ମ ହାତର ପ୍ରହାର ଶରୀର ହସାଏ ଏରୁଟି ବନ୍ଧରେ ଦିନକୁ ଗଣି କେତେ ଯେ ସପନ ନୟନେ ବୁଣି ଓଠରେ ରହିଛି ତା ପୁଅର ନାଁ ଅପେକ୍ଷା କରିଛି ମୋ ଯଶୋଦା ମା
directed as was observed in the order dated 2/12/2020. Considering the submission made by the Land Council for the petitioner, the time is extended till 20th of January 2025. It is made clear that if the appeal is not filed to answer, the order will not be made effective.
Urgent copy.
Item number 28.
Actually, on behalf of Mr.
Withdraw.
Misra,
All right.
actually, I am for the petition.
You want to withdraw the writ petition? All right, disposed of as well. Rest of the thing will be taken up on Monday.
Lord, once again, Lord. He just rose.